Okay, it is Tuesday, May the 4th, 2021, and welcome to week number 5. This is the 5th week of 6 weeks of 6 lectures, and we'll have one today for week 5, and there will be another one Friday for week 6. Just be aware of that fact. It's on the calendars. I think it's Friday. Um, yep, the 7th. So that'll be for week 6. And as you know, the course ends next week. Literally next week, this course will be over on a week from tonight. So I'm going to give you a few cautions. Uh, Make sure that you get your assignments in on time. Make sure that you follow the rubrics. And we're going to talk about the assignments for this week. And then on Friday, we'll talk about the assignments that are due for the following week. All right. So I'm going to go ahead and share my screen. Okay. And again, go to student preview. Okay. This is what you see as a student when you first open up. And you can check emails, of course, over here. And this tells you all the emails that were sent to me. Actually, they were sent by me to me. And if you look at yours, you'll see those that are sent from me to you. And then let's look at the grade book. So the grade book, here we are in week number 5. It provides you with the written assignments. There are 2. The discussion posts, there are 2. And then the live lecture. So let's look at the assignment. So unlimited attempts in written assignments tells you when they're due, May the 9th, which is Sunday at 11:59 p.m. And if you click on this, it actually opens up. Here it goes. And it tells you what you're going to do. So now, this is the project interview. Now, notice very carefully. It gives you the things that you do to interview a public defender, a private lawyer, or a judge, or a police officer. You can do that. The interview should take about 30 minutes or longer, and you should gather enough information to use throughout your paper as one of your main secondary sources. I already told you what secondary sources were. For this assignment, you're going to write a 1-page report outlining what you covered in this interview, who your subject is. And if you can get a resume, fine, don't worry about it. Now, because of COVID and the scheduling, a lot of people have trouble getting the interviews done. So what we came up with was an alternate assignment. And the alternate assignment, you see the original file, which by the way, I already posted it, but you can see it. And here's the alternate assignment. And I also provide you with the rubric as well for this alternate assignment. It's coming up in a second. There we go. Let me enable editing. Okay, so now you're going to follow the instructions on here dealing with the Fourth Amendment. And then this is some background information for you to help you. Okay, a lot of background information that I give you. I prepared this myself. Okay, now these are the landmark cases that I want you to consider. You don't have to consider others. These are the United States Supreme Court properly cited and everything. Then the exceptions. There are others, however, these are the ones I want you to consider using one. You ought to research one or more of the cases up here and pick at least one exception, one of these, to the exclusionary rule. Prepare a 2-page paper. In the paper, provide the details of the exclusionary rule, how it works and applies. Present your position as to whether you think the exclusionary rule is good or bad for the criminal justice system. Support your position. I don't know what's wrong with that word there. Nothing. Position using the research you perform to complete the assignment. Check your grammar, spelling, use APA. You know what that means. Cover sheet, double space, references as well. That's the alternate assignment for week 5. Week 5, very important. All right. So let's close that down. So this is, and then, like I said, there I provided you with the rubric already. So that's the written assignment for the course project. The next one is the written assignment, which is also due Sunday. And then here are the details for that. As you learn from your resources, in order for a confession to be allowed in evidence at trial, the confession must have been voluntary. Write a 1 to 2 page paper. Remember, APA, double space. Explain what would make a confession involuntary. I've talked about that before. Please include as many reasons as you're able to find through your research. Find and summarize a case where a confession was held to be involuntarily given. Do not use Miranda versus Arizona. A lot of people want to use that. Do not use that. Explain the court's holding, but do not use Miranda versus Arizona. Did you hear me? Use proper case citations. Your paper should be proofread for spelling, grammar, and punctuation. And then, as you already know, it should be in a Word document. Okay? Again, you have the rubric for that. All right, so that shows you how that works. And then your discussion post, which is the initial post is due tonight. Do you think the fifth makes a person look guilty? Is it better just to talk, to tell everyone you are going to incriminate yourself? Explain your answers. And in doing so, please provide the basis for the Fifth Amendment, not the fifth, pleading the fifth, and what it's all about. Explain that in your paper. In your discussion post. In other words, what is it all about? Where did it come from? Did it just come out of the blue? What's the legal basis for pleading the Fifth Amendment? Okay, so that's going to be your initial post that will be due, of course, tonight, and then your reply post is due on Sunday. All right. The second one is the Sixth Amendment, which I just told you now, but you should, I shouldn't have said it, but I said it. The Sixth Amendment, and it's in here. Based on your assigned reading, share your views on the Sixth Amendment. As guaranteed, does this right have more to do with the Sixth Amendment or with celebrity and money as the OJ case? What happens to this right when indigent clients go to trial and have no resources? What solution should further this? You should also mention the leading cases for the Sixth Amendment. There are two of them, and I will not tell you what they are, but if you research, you will discover that the original case, and all I'm going to say is I'll give you a real good clue about the first one. And that first one is involving a poor man who represented himself, and then and he ended up incarcerated. They did a movie that was done based upon it, and I won't say the name of the movie because it actually has part of the name of the case in it. And then there's a case that also is from Illinois that involves a person with a Hispanic name as the defendant as well. So you should mention those. And remember, when you mention cases, give proper citations. Initial post, again, due tonight. Reply post, due Saturday by 11:59 p.m. Central Standard Time. And then the final thing is your live classroom. A student, not in this class, asked me, how do they know the phrase? I say it actually during the lecture. You put that answer in here, type it in, and then you submit it, and it will show up in the Dropbox. Okay, and remember, you get it on Sunday. It's due by Sunday at 11:59 p.m. Central Standard Time. All right. All right. So now let's take a look at, well, let's go back to, yeah, let's go look at the calendar. I want you to see it from your perspective. You can do the month version, and you will see that this is where we are, May 4th. Your two initial posts due, your live lecture, and then also you will see that the next live lecture, this is week 6, is Friday at the same time. And then your reply posts for week 5 are due Saturday, the 8th. Then your written assignments are due, that I just mentioned, on the 9th. Okay. Then you see the course ends on the 11th. All right. And then we will talk about what's due at that time there. Okay. Because there is the initial post, reply post, and there's more to it than that. All right. But you'll see that when we go over it next week. So it's very important. Notice that if you get something after 11:59 on Tuesday of next week, the 11th, submit it. But I'll talk about that on Friday, but I'm just mentioning it again. No good. Won't take it. Cannot take it. Okay, let's go back to this. So now we're back to the regular view. And then just so to show you what it looks like from my perspective, there it is again, same information there. Okay, all right. So you want to make sure that you have that done at that time. All right, so we'll talk about that again on Friday. Okay, let's go to the announcement for this week, and you'll see several announcements. The alternate course project that I just got through sharing with you. Here it is right here. Based upon your research, one or more cases, provide at least one exception. And I didn't put everything. This is the rubric. This is the rubric, by the way. I'm sorry. This is the actual rubric. So you get 45 points for providing at least one exception that I've given them already. Explain whether you think the exclusionary rule is good or bad. You get 45 more points, and then 10 points for the proper APA grammar. All right. And then the course project. This is the alternate. Here it is right here. The one I just showed you a few minutes ago. That's the alternate course project as an announcement. Okay. And then, of course, the weekly announcement this week, suspects' rights. Chapters 10 and 11 of constitutional law, the text, I provided it for you, and deal with the activities, rights of suspects, which we'll talk about. And then it says I was found on lectures on Monday evenings. That's not correct. Actually, it's Tuesday evenings. As you already know that, though. Maybe that's why. Nah, every week it said Tuesday evenings, except here I guess I made a mistake here. All right. Then the discussion post that I talked about, do Tuesday and Saturday, and then your voluntary confession, and then course project do Sunday, and then you know what my motto, adversity is the springboard to success. I think that every week, I'm just curious, did I put Mondays on others? No, I did put Tuesday there, week 4. Yeah, every week it's been Tuesday, and then it's also in your course calendar as well. All right, so it was just a mistake that I had typed in here that I did not edit. Let's fix that. Fix that right now. Okay, so now I fixed that. That should, oops, that's 4. Oh, I got to post it now. There we go. So now it should say it correctly. Yep, Tuesdays. But you know that already. So that's the announcements. Okay, course announcements. So now let's go down and let's look at again the topics. So I'm not going to go over the interview and all of that. We did that, and we did that, and we did the discussion post, and we did the live classroom recording. So let's talk about what is involved here with the suspect's rights. Here we go, right here. Okay, so as you will learn that the basis for the rights of suspects dealing with the topics that we're dealing with this week pretty much deal with Miranda versus Arizona. And you know that the infamous Miranda rights came out of that. Now, you should be aware that they are very important, and that it is important for you to be aware that it says that the person must satisfy all of these points in terms of the warnings. Be told that you have the right to remain silent, and it means what it says. Anything you say can and will be used against you. You have a right to attorney, and if you cannot afford one, one will be appointed for you. Now, be aware of the fact that Miranda versus Arizona uh, changed a whole lot of uh, things that involve the rights of individual in terms of interrogation and confessions. I shared this before, that one of my law professors I had, Fred Enbow, who passed away, was the um, creator, along with a guy by the name of John Reed, of the techniques that the police department were using in Arizona that was the subject of this case. And the United States Supreme Court took time to say that these techniques violated the Fifth Amendment rights of individuals. And so as a result of that, if you read the full case, you will see footnotes in the full case about that. And so my professor took it upon himself, and he told us that he felt personally maligned by what the United States Supreme Court did, because of the fact that they decided that the rights of individuals that were under attack that he had, he took it personal. And so as a result, every year after Miranda, if there a case came that involved Miranda type issues, his deal was to do away with Miranda and have it eventually overturned. He's long gone, and it is now the 21st year, 2021, from 1966, and it's still standing. And so the point of the matter is that it's still strong. Now, the way that many police officers do it is they have a little card that they're given, like an index card, that have these, and then they read them to you. Sometimes, though, they will do it verbally. It is very dangerous, though, because if you miss any of these rights for individuals, that can open up the door for an attorney to throw out the statements that are made. And so it is very important for you to understand the importance of this case. So here's a few things that I want to share with you. Voluntary intoxication is not a defense to whether or not it's voluntary. So if you get drunk or high on drugs before being arrested, you cannot later claim that you didn't voluntarily waive your rights because you were high. But if you were drugged unknowingly, you may be able to contest it. It's the same way as they do with involuntary intoxication in terms of driving under influence, the same kind of things as well. Voluntary intoxication cannot be utilized as a defense, but involuntary can. The officers are allowed to tell stories or to get the suspect to talk. For example, an officer can tell the suspect that if he's honest and tell the officer everything that happened, he will get to leave custody, even if that's not true. That sounds like it's trickery, but remember point number 2. Anything you say can and will be used against you. And number 1, you have a right to remain silent. You don't have to talk. And by the way, once you invoke that right, they have to immediately stop questioning. If you come back, they come back to you later and say, you know, you say, I decided I want to talk. they can't do it because then they have to wait on your attorney. The rights can be invoked at any time, and the officer, as it says, must stop the interrogation. A suspect must actually verbally invoke it. So if you don't say anything, then that's not considered an invocation of the silence, even though it is. But if you say, I don't want to talk, that's another way of invoking silence, as it's cited in the Burgess case in 2010. A suspect must be in custody. Now, when you're in custody, you are in custody when you are not free to go. That is, that your liberty is taken away. So if you are in handcuffs, if you're surrounded by police, if you're put in a situation where it's quite clear that they're not letting you go, then you are in custody. And if they're going to ask you questions other than things like your ID and things like that, then they're going to have to give you the Miranda warnings, because any statements that you make then at that point could incriminate you. And we'll talk about that in just a few minutes. And that's what Miranda warnings are there for. So there's a whole line of cases that deal with the issue about what custody actually is. But I've kind of reduced it to taking away your liberty. I teach my students that are you under arrest only by saying that you're under arrest? The answer is no. When the liberty of an individual is taken away, that is when they are considered to be under arrest. Now, self-incrimination involves the Fifth Amendment, as it says, and here is the full Fifth Amendment here. And so a person that takes the Fifth, which, you know, it's in our discussion post, it says, referring to the highlighted section of the Fifth Amendment above, well, what that really means is that nor shall a person be compelled to be a witness against himself. Okay. And then there's the due process aspects of it, which means that you have a right to a hearing and to face your accusers and so forth. And you can't have property taken away, as in forfeiture cases, without just compensation or due process given to you. So taking the Fifth proceeding in a criminal proceeding or in a congressional hearing is given by a person when they believe that the statements that they might make based upon the questions asked might incriminate them, and you don't have to do that. Now, when a person takes the Fifth, during a case, the jury is not present, and generally prior to any testimony given. If in the middle of a legal proceeding, a judge will generally recess the jury and inquire further. If the judge agrees that the person will incriminate themselves, then the other side may request a mistrial because that person is doing that, or that all the previous testimony be stricken from the record as if they never testified, one or the other. But it's kind of hard to do that when you still have a jury. So the key thing that is so important is that you can't be forced to testify against yourself. All right. Moving right along to the next amendment, the Sixth Amendment. Again, under the Fifth Amendment, a person has the right to request counsel. That's part of Miranda. That you saw that earlier. You have the right to an attorney. All right. But so it says that. But under the Sixth Amendment, after a suspect has been formally charged with a crime, a prosecutor cannot speak to the defendant without the lawyer present, whether in custody or out of custody. So the point of the matter is that You can't even go to them and question them. The police can't go to them and question them. So to give some examples here. If Officer H brings in Sam to the station to interrogate him because Sam is a suspect in a retail case, Officer H must advise Sam of his Miranda warnings because he's in custody. If Sam invokes the right to counsel, Officer H must wait until Sam's attorney is present before continuing the interrogation. If he's held in jail and later formally charged for the retail theft, Officer H cannot question Sam again without the lawyer present. So it seals the deal. However, on the other hand, let's say he's released, no charges filed. And if the officer brings him again at a later date, then Officer 8 would more than likely have to, again, give the Miranda warnings. He'd have the same rights he had before to invoke his right to counsel. And if Sam didn't invoke it this time, a court would probably find that Sam's statements were made during the second interrogation as allowed in evidence because time has passed between the original invocation and clearly Sam understood his rights. Even if it's 1 day, it applies. So you get that quite clear. If a suspect is in custody on one charge, and while that charge is pending, the police are investigating him in another crime, and they bring him into the interrogation room to ask about the new crimes, new warnings are given. The suspect must be able to invoke the right to counsel and have his lawyer present. However, the police may not question him regarding the case that is already pending, for which he is formally charged without the lawyer present. Okay. And the example given, finally, is if Sam is charged with retail theft and he is later brought into custodial custody regarding domestic violence, Officer H must advise him of his Miranda warnings, and Sam must invoke. But Officer H cannot ask Sam about the retail theft because of what I said earlier, since the Sixth Amendment protects Sam, and he cannot be questioned without his lawyer present on that matter. So that's pretty much how things work under that. So it's very important for you to understand how these things operate. Okay? So that's all the information I have for week number 5. I will give you a key word or phrase for the week 5 lecture, and that is Sixth Amendment. Give me Sixth Amendment and you get your points for week 5. Okay, well, that's all I have for you today. I'm going to say good night to you guys. Be sure that you come back Friday for the lecture for week 6, in which I'll finalize that. Very important. All right, because again, reminding you the course ends next week. Okay, I'll see you Friday. Enjoy your evening. Stay safe.